Welcome to Time is Not on Your Side with your host, board-certified business litigation attorney, Robert Eckard. In every episode, you'll hear insights from Rob and those he trusts to impact the success of your litigation. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Now, here's the host of Time is Not on Your Side, Rob Eckard.
Hello and welcome to another episode of Time is Not on Your Side, a podcast dedicated to bringing you topics and a perspective you won't find anywhere else. I'm Robert Eckard, board-certified business litigation attorney and government investigation specialist with an LLM in international law and business. A quick Google search for the topic, stages of a lawsuit, produces over 24 million results. Perhaps the number represents people simply interested in the judicial process of litigation, or more likely, people and parties actually in lawsuits trying to understand the different stages of a lawsuit. So here we go, the 9 stages of a lawsuit. We understand whether you're a defendant or a plaintiff in a lawsuit, it can be a complex and confusing time causing stress and anxiety. Therefore, I put together a basic outline on this podcast that you can use and listen to familiarize yourself with how your case will progress. Now, I can only offer a summary of how the case will proceed, as each and every case is different. So first, the demand letter. There may be a demand letter sent before a lawsuit is filed. A demand letter is written by the plaintiff's attorney to either the defendant or the defendant's attorney. The defendant outlined the damage done to the plaintiff and what the plaintiff is seeking from the defendant, usually in terms of money, to avoid a lawsuit. And that a lawsuit will be filed unless the parties reach a settlement. This may lead to a resolution of the case before a formal lawsuit is even filed. Second, the complaint. If the case is not resolved by the demand letter, or if a demand letter is not written at all, then the plaintiff will file a complaint. Depending on jurisdiction issues, the complaint is filed in either state or federal court. The complaint is a written description of the plaintiff's legal claims and the facts that support those claims against the defendant or defendants. 3, the summons. After filing a complaint, the plaintiff must serve a copy of the complaint on the defendant to start the lawsuit. The plaintiff has 120 days from the date the complaint is filed to have the defendant served. Normally, a process server will serve the complaint on each defendant at their home or business or another address. Serving the complaint starts the clock for the defendant to answer or respond to the complaint. 4, answering or responding to the complaint. After the plaintiff serves his complaint on the defendant will usually have 20 days to answer or file another legal response to the complaint, unless a formal service is waived, thereby giving the defendant 60 days to respond to the complaint. The defendant will either 1, not answer the lawsuit, 2, file a motion to dismiss, or 3, file an answer and affirmative defenses and counterclaims. Not answering the lawsuit is obviously the worst choice because it can be deemed a waiver of any defenses and a default judgment could be entered. The plaintiff could then move for judgment and succeed without the court even hearing any defenses that the defendant may have to consider. This is like a technical knockout. When a team doesn't show up to the game that they're supposed to be playing in, they forfeit their right to compete and they lose automatically. The motion to dismiss. The defendant may file a motion to dismiss the complaint when all the material facts taken in the best light of the plaintiff's view still do not provide sufficient legal ground for the relief of that the plaintiff is seeking. The facts or a dispute in the facts is not argued during the motion to dismiss. Normally, the argument revolves around case law or statutory law. Neither the actual plaintiff or the defendant will have to appear in court for the motion to dismiss, but the attorneys will appear for their clients to argue the respective positions at the motion hearing. The answer. Assuming the defendant is not successful on the motion to dismiss or does not file a motion to dismiss, the defendant will file an answer. The answer will either admit, deny, or state that they have insufficient knowledge with which to answer each and every allegation made in the complaint. Affirmative defenses. In their answer, the defendant will normally put forth affirmative defenses which, if true, would negate the plaintiff's otherwise valid causes of action. For instance, in a breach of contract case, the defendant may put forth the affirmative defense of prior breach or fraud, claiming while the defendant did breach the contract, he did so because of the prior breach by the plaintiff or the fraudulent actions of the plaintiff. There are many affirmative defenses depending on the causes of action and the facts alleged in the complaint. Counterclaims. The defendant may also file any number of counterclaims against the plaintiff. Basically, a counterclaim is the defendant's complaint against the plaintiff. The plaintiff will then be called the plaintiff counter-defendant and will have to file an answer, affirmative defenses to the defendant, counter-plaintiff's cause of action. 5. Next is discovery. Discovery is the exchanging of documents and information each party deems material towards their lawsuit. Discovery almost always begins with written discovery, usually called interrogatories or written questions, requests for production of documents, which request a party to turn over documents, pictures, electronically stored information, and things of that nature. Additionally, requests for admissions, which require a party to admit or deny the veracity of certain facts and may include some other general information a party must provide by local rules or civil procedure. Depositions. Each party will be allowed to depose any of the other party's witnesses who may testify at trial, including any expert witnesses listed by the other side or that have information on the case. If you're a party to the case, you will almost always likely be deposed by the opposing party's attorney. At the deposition, you'll be asked to answer any number of questions regarding your knowledge of the facts at issue in the lawsuit. You'll be sworn under oath, and a court reporter will be there to write out all your answers down. Nowadays, it's not uncommon also to be videotaped during your deposition, which may be shown to the judge or jury at trial. Don't worry, we will be there for you, with you, and help you guide you through the process as it gets closer and prepare you for testifying. The number one thing to remember in your deposition is always tell the truth. That would be the most important thing, and that we would help you with strategic ways to answer questions being asked of you, including the possibility of invoking your Fifth Amendment rights. We will go through those ways that we will prepare you for your deposition in advance. Number 6, summary judgment. Any party may move for summary judgment, or a judge may determine that on their own initiative that summary judgment is appropriate, which means the case will not go to trial. Unlike with other pretrial motions to dismiss, information such as affidavits, interrogatories, depositions, and admissions may be considered on a motion for summary judgment. Any evidence admissible at trial may support a motion for summary judgment. Usually, the court will hold oral arguments on the summary judgment motion, although may decide the motion on the parties' briefs and supporting documents alone. Normally, the attorneys appear without their clients having to attend a summary judgment hearing. For a summary judgment to be granted, the burden on summary judgment lies with the party that has the burden of proof at trial. In other words, if the non-moving party must prove the fact to prevail at trial, the moving party at summary judgment can either produce evidence that the fact is not so, or point out that the non-moving party lacks evidence to prove that fact. To avoid dismissal of the claim or defense, that the non-party must then come forth with evidence to establish a genuine issue of fact for trial. Under Florida's new summary judgment standard, Florida state courts can weigh the evidence as a reasonable jury to determine the plausibility of inferences relied upon by the non-moving party. A mere scintilla of evidence or raising the slightest doubt is no longer sufficient to create a disputed material fact. There must be evidence strong enough that a reasonable jury could find in favor of the non-moving party. All evidence submitted for or against the motion for summary judgment must still be admissible at trial. Summary judgment can be granted if the party proves that the non-moving party, who has the burden of proof on the claim or defense at trial, cannot prove admissible evidence to support a fact material to the claim or defense. Likewise, summary judgment can be obtained by showing that the non-movement cannot bring forth evidence to refute a claim or defense asserted against them. The two criteria that must be met: 1, there must be no genuine issues of material fact, and 2, the moving party for the summary judgment must be entitled to judgment as a matter of law. Settlement. Before I go on and move on describing the next court proceedings, which will be trial, it bears mention that settlement discussions and settlement conferences can occur at any time, but are often more productive while summary judgment motions are pending. Statistically, all commercial litigation and even criminal or government investigation litigation, that 95% of those cases settle before trial. Don't be fooled by TV lawyers who spend all their time advertising and refer their cases to real lawyers who are actually in the trenches, I like to say, meaning in the courtroom day in and day out, trying and litigating cases. Settlement is not the result of lazy lawyering, but takes substantial preparation and keen advocacy. All right, number 7, mediation. Mediation is often mandated in civil cases before cases go to trial. This gives the parties an opportunity to settle the case before going to trial, saving both time and money. Mediation is one of the alternative dispute resolution mechanisms. A mediator is not allowed to decide who is right or wrong or to tell you how to resolve your dispute, but to find solutions and help you find solutions to the dispute and resolve some of your concerns. While the goal is to try to work something out, you may decide it would be better for you not to come to an agreement at mediation. Sometimes emotions can be driving the dispute, which can make talking to the person or party with whom you're in dispute with difficult. Mediators can assist you in easing the way for communication. The mediator is there as a neutral person to help you focus on solving your dispute. However, the mediator is prohibited from providing therapy, counseling, or legal advice. If the parties come to an agreement at mediation that resolves all issues, a notice will be sent to the court and the case is over. 8, trial. If summary judgment is not granted nor neither moves for summary judgment and the case is not settled at mediation, the case will proceed to trial. The trial will be in front of either a judge or a judge and a jury. Each side will have an opportunity to give an opening statement to the jury in the court, which is a short story of what the facts and the evidence will show and the witnesses the jury will hear from during the course of the trial. Each party will be able to call witnesses and each may testify on their own behalf. Likewise, each party will be cross-examined as the other side's witnesses. Each side presents his or her case, and each side gives a closing argument. The judge then instructs the jury on the law that applies in the case. Testifying at trial will be similar to the deposition, and anything you may have to said in your deposition can be used at trial. The trial will be more adversarial than the deposition, and again, we will prepare you for your testimony. After both sides have put on their cases and rested, the judge or the jury will deliberate and determine who the prevailing party is. If the plaintiff is the prevailing party, the judge or the jury will either determine the entitled relief or damages during that time, or a short separate trial will occur to determine damages only. 9, the appeals phase. After the motion to dismiss, answer, summary judgment, or trial, the losing party will have an opportunity within a certain limited time to appeal the case to a higher appellate court on specific grounds. For instance, specific grounds may include errors of law, errors of fact, or errors of procedure. An appeal is an entirely separate matter from the original case. That's a brief outline and summary of the 9 stages of a lawsuit. I hope that was helpful. If you have any further questions, please don't hesitate to contact me or another qualified trial and litigation attorney. This concludes another episode of Time is Not on Your Side.
You've been tuning into Time is Not on Your Side with your host, board-certified business litigation attorney, Robert Eckard. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, roberteckardlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others. The views expressed on this program are not necessarily the views of Robert Eckard and Associates, its attorneys, or guests. Any videos or other content presented on Robert Eckard and Associates' website or other social media platforms is for educational purposes only. All content presented is for educational purposes only and shall not be construed as providing legal advice or an endorsement of any third party or such third party's views, nor any private company or government agency that a speaker may be employed or affiliated with, or as a solicitation or offer to sell securities or provide investment, tax, legal, or consulting services, and shall not be relied on nor acted upon without obtaining specific advice from a qualified professional. We believe the information presented to be reliable, but is not guaranteed as to its accuracy or completeness. All examples are hypothetical and for illustrative purposes only. Any opinions or statements by Robert Eckard and Associates, PA employees, guests, or other third parties are their own and may not be representative of the experience of others or indicative of future performance or success. No compensation has been exchanged for any testimonials, endorsements, and/or recognitions. Past performance is not a guarantee of future results. No attorney-client relationship is established with the law office of Robert Eckard and Associates, PA, Lohr, until such time as a duly executed retainer is signed by you and an authorized agent of Lohr, and any retainer deposit paid and returned to us.